Other issue was the ordeal suffered by the accused men. And you may recall the lawyers for the accused men made a big thing out of this. You know, that's why they had filed all these medical reports about Cartel's health, declining health, saying that he can't sustain a second trial. They had filed affidavits from the other men. We heard Kahira Jones talking about the impact on his intimate and personal life. So the accused men made a big thing about the ordeal they would suffer if there is a retrial. Now, the acting DPP was countering this and saying, well, on the other hand, you have to look at the ordeal suffered by the other side, you know, the relatives of the victim in this case. Really, really strong point. But then she started to talk about the wife and the girlfriend, I beg your pardon, and the sister of Lizard, I presume. And then the judge just stopped her right in her tracks. And the judge said, you have no affidavit evidence to support what you're saying here. What does that mean? Lawyers are not supposed to give evidence, you know, in a matter. You're representing your client. The evidence has to come from your client. So if it is that your client is saying, hey, I suffered as a result of this, you have to have an affidavit from your client saying that. So to make a general statement that the families of the victims suffered, the judge said that's fine, but she couldn't then go on to say, Lizard's sister, Lizard's girlfriend suffered as a result of his disappearance and death because there were no affidavits from them saying that. And clearly that should have been there to make a much, much stronger case. Another issue was the length of time. And again, the lawyers from the accused men have been making a big issue about this thing, about time, you know, how long it's taken. They were arrested in 2011. They've been in custody since 2011. The appeal has taken 10 years. The trial was in 2014, went to the Court of Appeal, went to the Privy Council, now back at the local Court of Appeal for determination of this issue of a retrial. So the way in which the acting DPP was dealing with this was she started reading out a list, you know, of everything that had happened since the trial, appeal filed, leave for appeal granted, and she was going on and on with this. And the judge basically stopped her, and the judge said, no, what we need to know is, was there justification for the 10 years that this matter has taken? And it ended with the DPP saying she's going to need more time on this. So we might see them come back on day 5 and come back to that point. No. Okay, now they started to address the issue. What another prosecutor, Mr. Forbes, started to address the court on the issue of publicity, and they started on that. They're going to be coming back to that on day 5. But I want to talk to you a little bit about this issue of publicity because it is so important in this case. Now, they've been referring a lot to a case called Grant and DPP, which, you know, legalese language always sounds so boring and whatever. But this was a really, really interesting case. And I'd actually done a blog post on this in 2012, you know, when the whole cartel issue was heating up a long time ago, this thing, you know, just in different formats. Anyway, so I want to take you back to Grant and DPP because that was such an important case. Was actually an article that Professor Carolyn Cooper had written in the Gleaner, because, you know, she was close to Cartel. Well, I don't know how close, but she knows Cartel. So she had written a column, and she had said that Cartel had been complaining, this is in 2012, that he would not be able to get a fair trial because of the publicity. And let me just read for you what he said. She quoted him as saying, I'm being painted as this evil DJ by day, done by night murderer, who is society's #1 cause of crime and violence. The police is using the media to slaughter me. And as such, I don't think I'll get a fair trial. They're using the media to form public opinion of me that is so contradictory to the person that I really am. The police have tried my case and found me guilty. So that's what Cartel said, as quoted by Carolyn Cooper in the Gleaner in 2012. So as a result, I looked at one of our classic cases, we call it, on the issue of publicity on a trial and whether or not publicity would render a trial unfair. So this case, the Grant case, was really about the Green Bay killings. And this was in 1978, I think it was. Yes. Now, I know some of you probably don't remember the Green Bay killings, and some of you may have forgotten, but this was a huge story in Jamaica's political history. So the allegations were that a number of men had been lured to their death at Green Bay by members of the police, not the police, the army, the military intelligence unit. The reports at the time were that they were told they were going to be getting jobs, and they were told to come to Green Bay. And then when they came, they were killed, assassinated, shot to death. But some of them got away. All of them weren't killed. So some of them, I think it's five of them were killed. Some of them got away and spread the word. And then there was this whole thing. And then, you know, men were put on trial. No, there was a coroner's court verdict in the matter that said the men were murdered, but they couldn't say by whom. And then there was a trial coming out of that. And the really important thing, the reason this case is important is that there was such huge publicity around the case that the men were arguing they couldn't possibly get a fair trial. Now, let me give you an idea. Remember, this is 1978, so this is pre-social media, pre-internet, pre-WhatsApp, pre-X and TikTok and all these things. So you had the Gleaner, you had the Star, what we call traditional media, you had radio and TV. Okay, so let me tell you a little bit about the publicity. In the matter, there was a headline in the Gleaner. This is in 1978, and the headline said, "It was murder at Green Bay, says jury." That was reporting on the coroner's court issue. And the concern there was that people would read it and say, oh, them already guilty of murder, then guilty of murder for true. Then no, there was actually a song, you know, I can't sing, but y'all gonna forgive me because I have to share the song with you in case you know it. It was on the People Are You Ready rhythm, and it was by dancehall DJ Kojak. And the song went, "Green Bay killing a murder. Bow. Oh Lord." So, you know, once something makes it into the popular culture in a way like that, you also have an idea of its impact. There was also a Carl Stone poll. Carl Stone at the time was the, you know, preeminent pollster, and he had done a poll looking at public opinion in the matter. 75% of people who were interviewed said they knew of the Green Bay issue. 75. It sounds low to me, depending on how people are talking about it. But okay, that's what the poll said. 75% said they were aware of it. 57% of people said they had formed an opinion as to the guilt or innocence of the men, right? And then they actually counted, for instance, the kind of the numbers of articles that had been put out. They said there were 17 similar articles to an article in the Gleaner. That this is a different article. The headline was "Green Bay, What Made Them Do It?" And there were 17 similar articles in 1 month. And after the men in this case were arrested, there had been another 80-odd articles about it. So what did the court conclude? In short, because it went to the, you know, the trial court, then the Court of Appeal, then the Privy Council. And in short, what the court said is that it's not enough to show that there is adverse publicity that has affected some jurors. The bar is really high. What you have to show is that the publicity is so extensive that it is impossible to find a jury, meaning whether 12 people, 7 people, but it's impossible to find just the number of people to make up a jury that would be unable to carry out their work in an unbiased manner. So you can see how high the bar is. So I had said at the time, writing in 2011, that based on the Green Bay case, that's a grant, it would be almost impossible in any matter to argue that publicity made the trial unfair. We are now, of course, in the social media era, so you have all kinds of other considerations that come into play. Anyway, so Mr. Forbes now is addressing the court on the issue of publicity. And in short, what he said is that we have not reached that high bar that was set in the Green Bay case. We are not at the situation where it's impossible to find a jury that could sit in a retrial and hear the evidence and give a verdict in an unbiased way. No, the lawyers for the accused men had said that there are various remedies to try to cure publicity and prejudice. For instance, you can move the trial, you can delay the trial, and the accused men were arguing that none of those is feasible in this case. And in Jamaica, we're a small island. Mr. Forbes, the prosecutor, was saying, well, there are other things you can do. He said the judge can direct the jury. He said you can challenge the jury. Now, one of the issues, the judge was raising the question on social media. She was saying that the Green Bay case took place, obviously, as I've been saying, before social media. She also said that we had a situation in this case where some of the actual materials in the first trial, the voice notes, had been leaked to the public, and she said there are also the issue of the tainted juror, the juror who tried to bribe the others, because there was so much publicity about that. The concern is that there are a lot of people out there who feel saying, me think say a cartel and a man, they have something to do with the bribery, even though there was absolutely no link shown. And she said that's something the prosecution is going to have to address in terms of how that can be overcome. So very eventful day. We're coming up now to day 5, which is going to be the final day of certainly these oral submissions. But just on a note, the judge did say she has not yet got the list that the court has asked for from the Supreme Court, which is going to tell them the status of all the matters they've sent back for retrial over the past 6 years. She says that's something the court needs. And reminder, like and subscribe, and come back next time.